Hello again, everybody. It's nice to have you here again on the channel. And today we are going to talk about a new chapter of the lecture EU Law and Taxation. This is now part 6, and we are here. The EU fundamental freedoms and their impact on tax law. The first thing is I do not know if everybody of you is already familiar with the term the fundamental freedoms of EU law. That is simple what the single market guarantees as economic freedoms to the citizens and enterprises. So what you please do not mix up is the fundamental freedoms are economic freedoms. So what you can do in the single market, you should not mix it up with human rights like the freedom of opinion or freedom of speech or the abolishment of the death penalty and other things. All that is rather something which you can look for in the Charter of Rights of the EU. So fundamental freedoms is, from a general perspective, not so fundamental like abolishment of capital punishment or something like that. But the term rather comes from that they are fundamental for the functioning of a single market. So let's have a look to what these fundamental freedoms may be. There is the freedom of goods, the freedom of services, and the freedom of capital. So if you have a close look on that, how can you earn money? Either by selling goods, or by selling services, or by living on capital. So as you can see here, all the imaginable ways how you can earn a living are listed up here. And the system is indeed meant to have no gaps. Then there is a fourth freedom, and that fourth freedom consists of 3 sub-freedoms. Because when it comes to the free movement of persons, then the difficulties, which problems have to be solved in order to make it possible without problems that people can go to other states and work there, live there, and so on, are completely different depending on which kinds of people you have. There is first the freedom of establishment for entrepreneurs. That sometimes poses a question that if you, for example, have acquired a certain qualification in one country, that you have been examined and got the permission to do a certain job, that then it can be questioned if your education, training, and examination already guarantees a sufficient qualification to do the same job in another country too. For example, that will probably be different when it comes to architects. They probably what they have learned about statics and how a building must be constructed and designed, and so that is knowledge which they probably can also apply in another state, but perhaps that other state has other norms or legal requirements which might be different, so you cannot probably shift an architect without any problems from one member state to the other one. Or imagine you are a lawyer or even a tax advisor. For a tax advisor, you need very comprehensive education and training. In Germany, you need a state examination, which then gives you the permission to give advice to people in the field of taxation, because it's regarded as a very complicated field where you need a vast amount of details to know. Now imagine after having passed that examination in Germany, you now want to go to France. And now France has a completely different tax law, so what you learned here is probably not useful in France. So depending on the different professions, you will have to look for different solutions. Under which circumstances can you accept or allow somebody who passed an examination in another country and is allowed to do the job? Under which circumstances can you do that in the other country too? But in principle, the freedom of establishment for entrepreneurs is granted, at least if they fulfill all the rules of the countries where they move to, then they are allowed to work there. And the treaty says the council is allowed to issue directives or regulations in order to simplify the exertion of that right. The freedom of workers is in a different chapter because very often to apply for an employment entails less difficulties if you are employed by an enterprise. That enterprise is responsible for the quality and the qualifications which you have, so they bear responsibility, so probably moving is easier in most or many cases. And last but not least, you have a freedom of movement guaranteed to all other persons who are neither entrepreneurs nor employees. So persons not yet covered by all the rest. This is the most recent freedom of fundamental freedom, because until 1990 there was a gap. Until 1990 the fundamental freedoms only enclosed the right to free movement for people who were economically active, but not for people who did not earn money, like students or retired persons or children. So now, okay, so we have here an overview. Let's now look to these freedoms in detail. The freedom of goods just means that goods can be freely imported and exported between the member states without any restriction. So import restriction and export restrictions are forbidden, and also forbidden is any measure which has a comparable effect. So free transport of goods across the borders within the EU must be guaranteed or is guaranteed. We have the freedom of services. That means any restriction on the freedom of services within the EU is prohibited. So you can render a service cross-border to another member state. You can request or demand a service from another member state in your member state. So cross-border service is liberalized. The definition says that a service is everything which is done for money as far as it is not already covered by the freedom of goods, freedom of capital, or the free movement of persons. So it's a kind of catch-all the rest clause. The only thing is, if there is something of a non-economic nature, it would not be service, because if it's not for remuneration, then it's an idealistic thing, and there these rules do not apply, because they are market freedoms. So what has not to do with the market is not covered by them. Then we have the freedom of capital and payments. This freedom has a peculiarity because all restrictions on the movement of capital between two member states or all the member states is forbidden, but also all restrictions between a member state and a third country is also forbidden. So here the movement of capital is liberalized unilaterally, also with effect to other countries. Naturally, that's only unilateral. The EU forbids itself and its member states to restrict the free flow of capital from outside to inside the EU, or from the EU to countries outside. Naturally, the EU cannot make sure that other countries also accept free flow of capital cross-border. So if we say you are allowed to freely invest in, let's say, South Africa naturally can still decide if they are willing to allow that. Or the other way around, if we say every citizen of South Africa can without any discrimination, invest here in the EU, then it's still a matter for the South African legislation to decide if they want to allow this to their citizens or not. So that must be understood. Also, cross-border payments, so just paying an invoice or so, are liberalized. So the payment within the EU or cross-border payments from the EU to third countries or the other way around cannot be restricted. That is important because from time to time, depending on the currency regime of a country, there have been examples in the course of time that countries restricted the freedom of payment and said certain cross-border payments can only be made if the central bank permits that or does the transfer also. So here that is also liberalized. This is the only fundamental freedom which has general effect also in relation to third countries, and naturally it is also highly important for economic relations. Well, let's have another look. The freedom of persons, so the freedom of establishment that regards business owners. The freedom of establishment guarantees that a national of a member state has the right to set up an enterprise in another member state or an agency, a branch of an existing enterprise. So in tax language, that would be, in most cases, a permanent establishment or a subsidiary. So nobody can forbid you within the EU that you, as let's say, German national, decide to establish a capital company somewhere, let's say in Madrid, Spain. Spanish company law can or is not allowed to say Spanish companies can only be founded by Spaniards. That would be a violation of that treaty rule. Good. You are also allowed to act as a self-employed person. That's clear because also self-employed people are entrepreneurs. You are also allowed to manage your enterprise, your undertaking, as the treaty in an old wording says. So if, for example, you establish a 100% company of your own in France, you also have the permission to work as managing director for that company in France. And by the way, if you work for your own company, which you own, at least in part, and this is not a case of freedom of workers, then it's a case of the freedom of establishment because it's your enterprise. Then the treaty also regulates what counts as a company of firm of a member state. And they say every company or firm formed under the law of a member state. So even a partnership founded under civil law of Germany or company law of Germany, which has its registered office, central administration, so place of management, or principal place of business within the EU, shall be treated in the same way as a citizen of the EU. That's rather surprising. Because if you take that serious here, if a Mexican citizen establishes under German law a GmbH in Germany, that German GmbH is a holder of rights under the fundamental freedom. It has to be seen as a German enterprise and has the right to set up branches, subsidiaries, agencies in all other member states. So it holds rights under the treaty. The same if you set up a partnership, let's say an OHG under German law, and the three partners are a Mexican citizen, a Chinese citizen, and a South African citizen. Well, if it can be seen as a genuine German OHG with a genuine business here, then it is a firm established under German law. And then this entity has rights under the treaty. It can then establish, without being hindered, subsidiaries in other member states or set up branches there or whatever. So companies or firms means companies or firms constituted under civil law or commercial law or any other legal person governed by public or private law, except for those which are non-profit organizations, because they are not enterprises. This here is meant to guarantee freedom for enterprises, so for economic entities, profit-generating entities, for businesses. Good. When it comes to the freedom of workers, then every worker who is a national of an EU state has the right to apply for any job in another member state, to take and accept that position, then naturally also to travel to the state of the employer where the position is and to work there. That's common sense, but they wanted to make that clear. If you have the right to take a job in Spain, naturally you must be allowed to move to Spain and live there during the time when you work there. And now, as people, if they take up a job in a completely foreign country and live there then with their family for 20 years or so, if it's then a bit harsh to kick them out of that country after retirement, when they have fully been integrated there, then naturally the treaty, wise as it is, also says naturally the freedom of workers also allows these people to stay in their new home country, their guest country, after they canceled or finished their job, either in order to look for a new job in that country or because they have retired. So if you take up a job in another country, then you have afterwards also the right to retire there and live there as long as you want to. Naturally, there might be the question, what is a genuine job? For example, if you really apply for a job of 2 hours a week at McDonald's in Portugal, and then use this as a reason to say, I have now the right to spend the rest of my life in Portugal under the freedom of workers, that might cause some disputes with the local authority if that is the right legal basis. There is, I believe, already jurisdiction on matters like that. Good. There is at least one exception from the freedom of workers. Positions in the public service can be reserved for the nationals of your own state. Although I believe if you renounce on that exception as a state, so if you open a position to foreign applicants from other EU states, then you have to treat them without discrimination. Now, the public service is only a position which is combined with the exertion of state authority. So when you can give commands on others as an authority based on the right of the state to give orders to citizens. So if you are not genuinely a member of the state administration, that is not public service. For example, in Germany, many teachers, and historically in former decades, all teachers have been public servants. And so Germany brought forward that a teacher job in a state school is not open for foreign applicants. But then the European Court of Justice said, well, we cannot tolerate that trick. Otherwise, the freedom of workers could be indirectly hollowed out, undermined, terminated even effectively, by just declaring every job where we want to keep foreigners out as a job in public service and putting these people on the pay list of the state. That can't be. So teachers is not a job which cannot be done by private persons. This is not combined with the exertion of state functions in the stricter sense. On the other hand, the military, for example, the top general in an army, that position need not be offered also to foreign applicants. Imagine that the top general or the three top positions in the German military would be were held by an Italian, a French, and a Spaniard. Might improve the quality of the German army. I don't know, but that would be a genuine state function, which can be reserved to your own citizens. Okay, but in general, every job is open to applicants from other EU states too. The free movement of persons also includes all the persons not yet covered by other rules. That's Article 21 of the Treaty on the Functioning of the EU. And such people who do not move to earn money, that's, for example, students, because they do not move to another country in order to take up jobs there. Studying is not a job. You don't get paid. So when that gap was closed by the treaty in 1990, really every citizen of the EU had a right to move to another state. Again, the conditions under which that right could be granted differ on the grounds of, or according to who you are and what you are. In case if you are, let's say, self-employed and want to exercise your profession in the other country, you need to comply with the local rules, or at least have to comply with sufficient quality requirements. In case that you are a worker, there might be the one or other rule. Then there also need to be some rules coordinating your social security system contributions and so on. And in case of a student, for example, it must be regulated which requirements one can pose that you get the permission to live in the country while you are studying there. It's also highly recommendable if you allow students from other countries to come here and study here, then to provide rules that the examination and the academic grade which you got here will later be accepted as genuine and qualifying in your home country or other EU countries. That is the reason why there are also directives on under which circumstances an academic education has to be accepted as sufficient and as equivalent to the education which is offered in your own state. Also, retired persons, they cannot exercise the free movement of workers because they don't intend to work. But imagine you worked hard in Germany lifelong and you always dreamed of passing your retirement age in Spain, in the on the sunny beaches of Spain, and then to buy a small house there. This is also protected by the freedom of movement of persons. Well, naturally, what was foreseen was the risk that poor people would then shift their residence to that country where the financial support by the state was highest. And in order to prevent that, the free movement of such persons can be subjected to requirements by the member states only to a very small set of necessary requirements, which is explicitly accepted by directives of the EU as necessary. Only these requirements can be asked for, especially for such persons. A member state can require that you have financial means which are sufficient to live there, so that there is the perspective that you will not need financial support by your guest state during your time where you live there, and that you have a health insurance which covers your health risks sufficiently, so that you also do not lead to financial burdens for the guest state in that area. By the way, jurisdiction has already clarified when you move into a state and the perspective is that you can prove that you have a perspective under reasonable circumstances and with high probability you will never need financial support, you have sufficient means, and you have a health insurance. If later then, by a coincidence which nobody could foresee, you fall into poverty, you have the right to equal financial support in the guest country. The only thing which is prohibited or which can be prevented by national law is that you travel into a country where you can already foresee that you will need financial support by them, so that poverty is already guaranteed. They do not need to tolerate this, naturally. Okay, so that's the background of these fundamental freedoms. And if you look to the list, we can either speak of 4 fundamental freedoms: goods, services, capital, and persons, or we can make a list and then have 6 of them if you count freedom of establishment, freedom of workers, and free movement as different freedoms. You can nevertheless remember or memorize that each person can only have 4 of the freedoms, because you can either be a business owner or a worker or someone else. Okay, now let's move on. All these freedoms have, according to the text of the treaty, 2 things in common. The first thing is that all these freedoms explicitly underline that whoever uses them must never be discriminated on grounds of his or her or its nationality. It's in case of companies and so on. So no discrimination on grounds of nationality is allowed. That is meant effectively, so also indirect discriminations on ground of nationality are forbidden. So what will never be accepted is to say we do not inflict negative consequences or disadvantages on that person because he is a Belgian citizen. Oh no, we don't. Only because before he came he lived in Belgium. That's something different. And the answer here is no, that is mostly the same, so it would also be forbidden. Or we do not inflict discriminations on French persons, only on the persons who do not fluently speak German but have a French accent. Naturally, that's also the same, would be forbidden. A very, very refined way of discriminating against foreigners is, by the way, to say the foreigner itself, no, not itself, sorry, the foreigner himself or herself is untouchable, will never be discriminated, but everybody who does business with such a person, or everybody who has contact with such a person, will be completely beaten up by our police or our legal system. So you choose that way. We do not inflict harmful consequences on the foreigner, but we take great care that nobody wants to have anything to do with that foreigner. So discrimination of the business partners or contact persons of that person, that would be a very, very clever trick. And naturally, jurisdiction says this is also forbidden. And every person who suffers a discrimination, covert or open, on grounds of doing business with a protected EU citizen who made use of such a freedom, has an own right to object against that treatment in court, and the courts and even the authorities naturally must protect that right of or that's right of that citizen to get an equal treatment with the people who do business with the nationals of that state. Naturally, you could also cleverly discriminate against foreigners applying here for a job if you do not discriminate these foreigners but their family. It would be a very wise and clever trick. Hey, Mr. Smith, you come from, oh, England is out, so let's take Ireland. You come from Ireland, you are untouchable. We will always respect you, treat you like if you were one of us. But your wife and your children will be completely discriminated at every corner of every street, will be beaten up by the law everywhere, have no protection. If they go to a police station and complain, they will be thrown out. Bloody foreigner, go! Or do you have a job here? No, I'm not. Somebody making use of the freedom of workers, so go, you have no rights at all. That can't be, because that would mean you as an employed person go to your job happily in the morning, come home, your wife, your children weeping. The whole family suffers. You have a job. That would mean that nobody, no honest and honorable person could ever dare to take up a job in another country. Naturally, you could leave your family at home, but also that is something which cannot be demanded from most people. Most people have a family in order to live with them, so you can't say you can take up a job here, but you must leave your family 1,000 kilometers away at home and are not allowed to see them. And if they come, they are without any protection. So naturally, an implication of that rule that people who make use of the freedom of establishment or freedom of workers or so, a natural implication must be that the protection against discrimination is automatically extended on the family members of that person. Otherwise, that person would indirectly, again, be without any protection. You could harm them just by harming the family, and that must be logically forbidden. Well, so the rule that non-discrimination has to be guaranteed is very, very wide if you look at it and take it seriously. The second thing all these freedoms have in common is that any restriction of these freedoms is forbidden by the text of the law. A restriction, well, what is meant? A restriction is any measure which could hinder you from using these freedoms. Now, if somebody has then exercised one of these freedoms, although under great difficulties, you could always argue, well, then it was not a restriction. We made it a horrible trip to apply for a job in Germany, but in the end you took it. So that's the best proof it didn't hinder you. But in that case, one could probably say, well, but 99 others stayed at home because the obstacles were too hard for them. And it would be not fair to say, well, one of you managed to get the job and overcame all the obstacles, so we didn't hinder you. It was your own free decision to stay at home. That's not fair. And so jurisdiction says, well, also any measure which makes the use of these freedoms less attractive is also automatically classified as a restriction. So if I set up a system of legal rules which still makes it possible, let's say, to apply for a job in Germany, but turns this application into a horrible trip, so that you will probably refrain from doing this, is also a restriction. Now the question is naturally, what is less attractive? Because less attractive requires a comparison. And so with which situation do you have to compare? Jurisdiction usually says if certain rules make the exertion or usage of a freedom less attractive, that has to be compared with how the comparable inland situation is treated. So if somebody from France applies for a job in Germany, and the procedures and the bureaucracy is 100 times more complicated than if a German applies for a job, then this is definitively a restriction. Now, what if it's only twice as complicated? Well, then it's also a restriction. Less means less attractive, means probably there can be no threshold where you say, well, a small additional amount of negative things that can be tolerated, because these small things can add up, and these small things can also keep people away. A certain percentage of people will be kept off by the small additional things which you inflict on them. And so jurisdiction says no, everything, even a small thing which makes usage of such a freedom less attractive than doing the same thing by an inland person, that already counts. So there is no arguing, or there is no argument accepted that it's only a small thing which you do to the people. Everything counts if it makes looking for a job, investing capital somewhere else, or setting up an enterprise as a foreigner here less attractive compared with the comparable situation in an inland case. Now, the question which makes the whole thing funny and interesting is that these fundamental freedoms are rules with a high importance, but on the other hand, that you cannot apply them without any exception. Because, well, the treaty had to accept that certain situations, or that the fundamental freedoms cannot forbid every measure which can be seen as a restriction. So because of that, either the treaty rules mention exceptions, then it's clear they exist, or jurisdiction found out that must be a case where a restriction must be implicitly be tolerated by the treaty. Why? Why and in how far can we argue that the EU treaties, although they do not generally allow exceptions, nevertheless tolerate some things as allowed restrictions, although they are restrictions, have a negative impact on the possibility to use these freedoms? Well, that can best be shown by some nice examples. Let us just assume the contrary. What would happen if there were no possibility under the treaties allowed for the member states to take some restrictive measures? What would happen then? Well, you would first say, then we would have the full freedom of establishment, the full freedom of services. So we would have paradise on earth. But now let's look to how paradise on earth would then look. Example one, imagine you have a professional killer. Let's say he comes from Italy. That is probably not true. You know, all these mafia stuff, that's romantic prejudices against Italy. Probably in real life, the people of South Italy are, due to that prejudices, the most honest people on earth, because everywhere. So that's probably not true, but he must come from somewhere, so I took now Italy. Now our mafia murderer comes to Germany and shoots a victim in the open street. Everybody sees it. Police is even at hand, because a policeman stands at the corner when our killer takes a gun and shoots down a victim. Police comes, arrests our killer. Killer does nothing, doesn't defend himself. Then says, give me a lawyer, and by the way, I object to my arrest because I am the citizen of a member state. I am an Italian citizen, so I have the right for freedom of services. Well, and whatever you think about my job doesn't matter. It is a profession where I render services paid for money. Killing people is just a profession, okay? Nobody likes it, but there must also be jobs and professions who are not well liked. So that's just my job. It's also a cross-border situation. I came from Italy with an order to shoot somebody in the street. That's just guaranteed by the treaty. Freedom of services. Whoever provides services can go to another member state and provide his or her services there under under the local rules, okay, and a member state is forbidden to hinder me from doing my job. Now, you say under German criminal code it's forbidden to murder people. Okay, I accept this. But now we have a conflict. Freedom of services says I have the right to render my services here, and the criminal code says no. And arresting me, by the way, is well, something which effectively hinders me. It doesn't even not only make the job less attractive, it really hinders people from doing the job. So it can't be allowed. So the treaty says you can't arrest me. Criminal code says you must arrest me. That's a conflict of laws. EU law prevails, so please release the handcuffs. I still have to kill 3 other people tomorrow in the evening, so I would claim financial damages if you hold me in prison for longer times. That would be possible if we held the view that the EU freedom of services allows no restriction at all. So, and now you can see this cannot have been the intention of the legislator. When the people wrote the text and the member states agreed to the text of the EU treaties, they cannot have had in mind such consequences. So, although they forgot to mention this, it must have been common sense and silent, implicit agreement between them that at least this case, which I just outlined, cannot be protected by the freedom of service, that in such a situation, a member state would be allowed to apply its criminal code and arrest the murderer. Okay. The wording of the treaty doesn't allow it, so the only conclusion can be implicitly between the lines by silent agreement, although it has not been mentioned, at least this case can be treated in a way that the murderer is arrested, so that a restriction, which really makes exertion of the freedom of service in that sector of industry impossible, effectively impossible. If you shoot people in the open street for money, you are hindered to do your job. It's hard if you hold such a job, but it is evidently the correct legal solution. So we are forced to the conclusion that the treaty must have between the lines a permission for the member states to apply certain measures which can be classified as a restriction because they are absolutely necessary, because otherwise the whole civilized world would go under. So, and now we can even illustrate that with other examples. For example, imagine there was a convicted murderer in Austria. The guy had murdered his wife and now goes to court and says, my imprisonment effectively hinders me from using my right of free movement. I want to move to Spain and live there as a retired person. The only conditions which a member state can require is that I have sufficient money to live there. Yes, I have, and that I have a health insurance which covers all the necessary risks. Yes, I have. So my imprisonment here in Austria for the trifle of having murdered my spouse hinders me to exercise fundamental freedom. And now the trick is that the EU rules in the treaty explicitly say these people have the right of freedom of movement, or everybody who is an EU citizen has the right of free movement, and restrictions can be created only by laws of the EU. So what happens here is my imprisonment in Austria is an obstacle for free movement, which is created by national law, so it cannot be allowed. It's not legitimate. Naturally, this case will probably not be decided in this way in court. You will also have to draw the conclusion this can't have been wanted. It must be implicitly allowed to arrest such a person. By the way, I brought this example, which is a bit similar to the previous one, because this example is modeled after a historical case. Quickly after, in the 1990s, the freedom of movement for the remaining classes of persons was introduced. Then really somebody who was a convicted murderer in Austria and a former judge, which made the whole thing a bit awkward, really tried to bring forward that in an Austrian court. And then the Austrian court really did something special. They said, okay, the guy argues with European Union law. The outcome is evidently nonsense, but it depends on if we have to interpret the new freedom of movement in a strict way, or if we can also assume there is an implicit exception allowed, and this is something which we have to ask the European Court of Justice. So they asked the ECJ for a preliminary ruling on exactly such a case. By the way, the ECJ tried to talk itself out of the responsibility. They didn't want to have the first case on the free movement of person centering around a person who wanted to be released from prison, or I believe it was a home for mentally ill persons. So they tried to avoid giving an answer and preferred to talk about other cases. But indeed that happened, and the Austrian court took the matter serious enough to ask for a preliminary ruling that shows how high the rank and the value of these fundamental freedoms of EU law is. Now, from these examples should be clear there must be certain restrictions which the fundamental freedoms tolerate, although they are not mentioned in the text. Some exceptions have really been clarified in the text explicitly in the course of time, or even at the beginning when the treaties were wrote. Many others have been forgotten, and so very often when there is a conflict that something can be classified as a restriction, and the question is, well, what if we have to renounce on it? And then half of the world breaks down for us. Then you have to ask the European Court of Justice, is that one of the cases where we can say, when we interpret EU law, that the treaty silently tolerates such a restriction? This is a question how the treaty has to be interpreted. And so you have always to ask the ECJ. Now the ECJ doesn't want to be bothered with any potential measure of national law which can be seen as a restriction. So in the course of time, they made a catalogue, a testing catalogue of 4 criteria. And they said, usually a restriction will be tolerated by the treaty as necessary if it fulfills all the 4 following tests. The first thing is the measure must serve a legitimate aim of public interest. For example, in the case of our professional murderer, yes, to prevent murders is by arresting murderers. That is a legitimate aim. Now, I once came across somebody in literature and TV who was really outraged by the idea that the EU can decide what is a legitimate aim of public policy. And the answer is no, they don't. A legitimate aim of national legislation is, from the EU perspective, every aim which is not illegitimate under the view of the treaty. So, what would be illegitimate? If your aim is to undermine an EU rule. For example, if the EU rule says we have free movement of workers, and you say the aim of my national law is to keep all these Dutch, Polish, and Italian people away from the German labor market, that would be illegitimate, because it's not legitimate from the treaty perspective, because in the treaty you promised explicitly to do it the other way around, to open your market. So it cannot be a legitimate aim that you want to breach your treaty obligations. Even a nonsense aim can be legitimate. For example, if I were now the German Chancellor, which, by the way, would be a pity for the nation, and if I, in a fit of madness or out of a fit of strange humor, would say it is an aim of national policy that in every garden behind a house owner should hold at least one elephant. Okay, this is absolute nonsense, but a member state is absolutely free to follow every policy which that member state didn't promise to the EU. We don't do it. We never promised something about, at least I believe, that we renounce on that everybody has to keep an elephant in the garden as a pet animal. So that would be still a legitimate aim of public policy, as long as nobody can demonstrate that this aim explicitly wants to undermine an EU policy. If there were, I don't know, a directive that elephants have to be held in good conditions, then it would probably directly violate that obligation if you say you hold them in a garden which is 10 square meters. But if you don't find such a thing, it is a legitimate aim, full stop. Illegitimate would be we want to hinder the single market to function, for example. We want to keep foreign capital away. We want to keep our capital in our own country. So we want to undermine the free flow of capital. We want to do this and this. Purely economic aims are probably illegitimate if their aim in the last consequence means we want to undermine the proper function of a common market. The next thing is the measure in question must be necessary in order to achieve that aim. That's clear, because a measure which does not work deserves no protection. So it should be abolished. And naturally, it's also necessary that you demand that, because otherwise I could always bring forward an aim and say this is a legitimate aim, so my measure is allowed. But if the aim has in real world nothing to do with the measure, I could always invent an aim, a legitimate aim. I have a certain tax rule which prevents people from buying French cars. That serves the legitimate aim to make it possible that everybody holds an elephant in the garden. Then you would, with genuine surprise, say, please explain to me what has the one thing to do with the other. And my answer would be, well, nothing. The measure is absolutely senseless, but it serves a legitimate aim, believe me. So you could under a pretext justify everything if the aim alone would be sufficient. So you need to control also to check if the aim also, the measure also serves the aim sufficiently. Now, you can also have a choice between different measures which serve the aim. And now, as it is clear, we tolerate things which are necessary, but nothing more. The measure must not be excessive. If you do more than is necessary to follow your aim, if you inflict more harm on the fundamental freedom that is absolutely necessary, then that can't be tolerated. You must restrict yourself to the measures which are necessary. If one can clearly prove that the same aim can, in the same extent, be reached by milder measures, then your measure is, in the current extent, not allowed, because it's overdoing things. And the fourth criterion is the whole thing must work in a non-discriminating way. That does not mean discrimination on grounds of nationality, although it includes it. But the thing is plain and simple. It could be that in a cross-border situation, you look to an aim and take every necessary measure to safeguard this aim, for example, public health. A historical case was when milk was imported from other member states, a state said, when the milk comes to the border, it must be, pasteurisé, or such a thing. It must undergo a special treatment which kills all the bacteria in the milk, and so. And the aim is to safeguard public health. Legitimate aim, naturally. Is the measure adequate? Can it reach that aim? Yes. In that milk, everything's dead and gone. Only the milk is left over. Now it's pure, without any potential harm for human consumption. Is there any milder means? No, this is an adequate and not excessive measure. You can't guarantee that the milk does no harm without killing all the bacteria in the milk, so perfect. But then it came out that the same member state allowed people to buy milk directly from a cow and to transport it in dirty cans home and drink it there. So when milk came from another member state, health protection mattered. When it came to how can my own farmers sell their milk, nobody cared about public health. Then people could die in the streets from infection. Nobody cared about that. Only when the bloody foreigners sent milk to that state. So the ECJ said, first three criteria are met. Okay, but you treat the problem in a discriminating way. When it comes to your inland cases or your own citizens, you don't care about the problem at all, or you care about that problem far less. So that shows that you only become to work in an exact way when it comes to foreigners. That's a discrimination of foreigners, and that is a forbidden restriction, because here evidently health care is a kind of a pretext to keep the foreign competitors away from the market. So these are the ideas under which the European Court of Justice reviews a national matter and decides if such a measure can be justified, tolerated, or not. And usually, according to the fact that this is a standing jurisdiction, they usually just tell the national courts, please have a look to these four criteria and only ask us if there is a doubt what they imply and how they have to be applied to the court, to the present case. Because if some measure fulfills, in fact, in real life, all these four criteria, something which we don't know, only you know it because you know your legal system, then the measure is okay, otherwise not. Now a last question remains. All these fundamental freedoms do not mention tax law at all, at least most of them. They do not explicitly say you have to refrain from writing certain tax laws. They just say there is a freedom of establishment. Now, how the hell can people conclude from these very general rules that there are implications for tax law? That is something which you need to understand, because that is surprising. Well, again, you can show this by some nice examples. For example, let's imagine the assumption the freedom of establishment, the freedom of movement, and all these things have no implications for how you have to write a tax law at all. So when you write a tax law, you don't have to bother about these things. What could then be the outcome? Well, imagine I want to get rid of foreign workers in my country because my job market, labor market is down at the moment, or for what reason ever. Now I could say we promised citizens from other EU states you can come and apply for a job in our country, and we stick to our word, you can come. Now, surprise, however, you will have to pay a tax of 99% on your income in our country, because we are free to write our own tax law, and the Fundamental Freedoms text doesn't speak about consequences for tax, so there is no consequence for tax. So we can do in the tax area whatever we want to, and we want to take 99% from you. Congratulations, but you can come. You are absolutely welcome, but when you come, 99%. I think we can agree that the actual outcome of such a situation is all the others stay at home. I can't go to Germany. If I earn 1,000 euro, 10 euro are left over. Can't live from that. So you would have effectively banned all the others from coming here. You would have turned the freedom of workers into a fiction, and that is what evidently can't be meant by the treaty. Now, as one can write taxes relatively arbitrarily, at least that's the opinion of several politicians, this could always be done. And so you can only draw the conclusion, no. If the treaty is meant to work actually effectively, then this model, this example must be forbidden. Such a behavior must be forbidden. You could also say, everybody has the right to invest his or her capital, not in our country but abroad. We signed in the EU treaties, free movement of capital. Yes, you can do it. And now let's have a look to the tax code. Okay, the tax rate for income from investments in a foreign country is set by us at 105% of the income in the first 2 years or so. How surprised. Will a single person afterwards invest abroad again? No, but you can. You have absolutely the right to do it, okay? It will end up in economic self-destruction, but you can. We give you that right. We never question that right. You will voluntarily refrain from using it. That can't be meant by the treaty. It would be a fiction. It would be a sham and not a right anymore. Yeah? So the same. Everybody has the undisputed right to leave our country and then move to Spain to spend his or her retirement there and enjoy it. There is only one small peculiarity. When you leave the country, you have to pay a final wealth tax. And at the moment when you leave the country, that wealth tax is 80% of your current wealth, of all your property you have. Well, you can leave. Congratulations if you do. Okay. Now, question, who will ever leave our country? And still, answer, nobody. Nobody will ever afford this. Only the poor, perhaps. Okay, perhaps I want to get rid of the poor and keep the rich in my own country. And if the rich go, then they arrive in Spain and are poor. Would also be a surprise. So these examples show if fundamental freedoms are to be taken seriously, then they also imply that there can be no right of a member state to turn these rights into a mere fiction, into a sham. And as tax law could always do this, it must be forbidden to design tax law in a way that freedom of establishment or other freedoms are restricted. Now the question is, okay, where does the restriction begin? And the answer is, well, a bit less attractive already has the effect to keep a bit of the persons away from using their freedom. So only equal treatment probably can really safeguard that these freedoms are not impacted. You can vary the whole thing. You can't say with 99% tax on the job salary, it brings down the freedom of workers. With 90%, it does not. So you can only be safe if you have equal treatment when there is no restrictive effect at all. And so you end up in the end at the necessary conclusion that tax law, as all other areas of legislation, has to comply with the general standards of the fundamental freedoms. You can freely choose solutions for your tax law within that scope which is left over. But to design your tax laws in a way that the taxation of cross-border situations renders doing such a thing less attractive than the inland case is always suspicious and is only allowed if it can be justified as a restriction, because it is in principle a forbidden restriction by the fundamental freedom. And the same applies with effect to discriminations. You cannot tolerate such things, and that is why very often in many cases we have to view all these things under the aspect, can a tax law violate some fundamental freedom? Especially when you study international taxation and law, you are always dealing with international situations, cross-border situations. So funnily, very often, in all internal cases within the EU, you have cross-border situation which is covered by one of the fundamental freedoms. Remember, goods, services, capital, all the three ways in which you can earn money and income. And even investing capital in third states would also be very often covered. So it is very important to deal with all these details. So we must draw the conclusion that tax law must be bound. The discretion, so the options which a legislator has to choose solutions in the area of taxation, must be restricted in a certain way by the fundamental freedoms. Otherwise, the whole world would break down. Otherwise, these freedoms and the treaty text would just be turned into a fiction. Then the question naturally is, where do we have to draw the lines? What can we accept as something which is not a restriction at all in the tax area? What is a restriction which is silently tolerated? Here we will have to think about how we have to check these four criteria and what does jurisdiction say on different aspects. And that is something which makes the dealing with the fundamental freedoms interesting, and that is something where we will have to talk about during the next parts of this chapter. Thanks for watching and hope to see you again soon.